Hello, my name is Ellen Schurdak, and I'm here today with one of my partners at KingSpry, Karley Biggs Sebia, and we're both operate out of our main office in Bethlehem, Pennsylvania. Good morning, Karley.
Good morning, Ellen. Thank you for having me.
And today, we both thought we would talk about physicians' employment contracts. And one of the reasons we wanted to discuss this today is that this is the time of year when many doctors who are finishing up their residency program or being an intern are for the first time going out and getting job offers as a physician from most likely a health network. Karley and I both regularly review these types of contracts, and we thought we'd discuss some of the highlights. And so, Karley, I wondered if you could start off our conversation with some of the things you might look for when a doctor comes to you with a proposed employment contract.
Sure. Well, I think there are three main objectives I look at when I initially review a contract. First, I'm looking at the scope of work. Are you being asked to do what you want to be doing and what you've agreed to be doing? Second, and probably most important, is your compensation. How is compensation structured? How specific are the terms of your compensation and how you'll be compensated? Are they clearly identified in the contract? And then the third major component is post-termination. What rights do you have post-termination, whether that termination is for voluntary reasons or involuntary reasons? And that would include non-competes and non-solicitation language.
Okay, and in terms of compensation, do you see signing bonuses as an area that can be negotiated?
Sure. Yes. Over the 10 years that I've been practicing and reviewing these types of contracts, I have seen a shift to larger signing bonuses. I think a lot of hospital systems are really using them as a tool to entice physicians to accept positions with them. And signing bonuses are obviously great, but there are some things that physicians need to be aware of as they're negotiating signing bonuses and accepting these bonuses. The first being tax implications. Because you're accepting, and oftentimes you're receiving this signing bonus prior to your start date. So that may result in you receiving a 1099 as opposed to a W-2. So you want to be aware that you may not have taxes taken out of it. So the amount that you think you're receiving, you may need to put aside money to pay those taxes. You also want to be aware that there may be repayment requirements. So along with non-competes, one way that employers have some control over employees and whether or not they stay with their organization is they have really strict repayment terms for signing bonuses, moving expenses, and that sort of thing.
So if I were to terminate or to leave employment, didn't serve out the term of my contract, I might owe the health network a portion or all of my signing bonus back.
That's correct. And typically what we see is that it's a decreasing scale. So after your first year of employment, if you leave in that first year, you may be required to pay the whole amount back. If you complete your first year and you leave within your second year, you may owe 50% back. So it really just depends on what the agreement says. It's what the parties agree to. Another area that I think is important just to mention is also tuition reimbursement, which is treated separately from signing bonuses. But a lot of hospital systems have been using repayment, giving you money to repay your student loans. And similar to a signing bonus, there are tax implications that you want to make sure you're talking to your accountant about before you accept that type of compensation.
And certainly the physician's salary is an area to be negotiated. And I know in the medical field, compensation is very often tied to what's known as WRVUs. But again, I think the way health networks treat WRVUs can vary from contract to contract. And I wondered if you had any insight on that issue.
Yes, I can't tell you how many times I've heard a physician say, when I've asked if they understand or they know how they're going to be paid, they assume they know how they're going to be paid just because they're being told that they'll be paid based upon their work WRVUs. And that's only one piece of the picture. And a lot of times this may not be something you can negotiate, but it's something to be aware of. So you want to ask certain questions ahead of time before you sign these agreements. You want to know, are your WRVUs credited based upon this service you provide, or is it based upon reimbursement that's actually received for the service? That can really make a big difference in your compensation. You also want to know whether reports that are generated indicating your WRVUs, are they using a date of service, or are they using a date that the service was billed? That can have an impact on the timing of when you're getting credit for these WRVUs, and could impact your compensation. You also want to talk to the administrators and find out who's authorized to change codes, how codes are bundled. There is an art to these codes, and you want to make sure that whoever's authorized to change these codes, first, that you receive some notice that the codes are going to be changed, just so you can keep some element of control over those changes. And it also doesn't hurt if, it can be difficult depending on your specialty, but reviewing the WRVUs calculations and keep your own list, and do a reconciliation at the end of every quarter or every month to make sure that you're actually paid for the work that you're doing.
And some employment contracts, at least that I've seen, have used a mixed approach with WRVU requirements. I'm not sure if you've seen this as well, where a physician's productivity is one part of the measurement, along with that physician's practice group. Have you seen that as well, that it might be a mixture of the two?
Yes. And that's why it's particularly important to have an attorney involved in reviewing your employment contract before you sign it, because there are a lot of nuances that can really have a significant impact on the compensation. So especially when you're comparing different job offers, you want to make sure that if compensation is one of your key factors in what you're considering, you want to make sure that you're considering everything that's involved in the compensation from a particular potential employer.
And likewise, if you're going into a practice group that has a large population of patients who are Medicaid, that's also going to affect your WRVUs, is it not?
That is
lower reimbursed scale.
Correct. Yes, that is correct. One thing I also want to make sure that potential employees understand is that there are also the Stark Law and anti-kickback laws that go into consideration when you're talking about compensation. So it's not unusual for there to be provisions in a contract that say that your whatever your salary is, or whatever your compensation, we'll use the term compensation, is, including bonuses, including signing bonus, including loan repayment, those are subject to audit. So you may see there's some fluctuation in your compensation based upon that audit. At the end of the day, essentially what your compensation needs to be, it needs to be fair market value. So that's just something you may see in an agreement, and I don't want you to freak out about it, but it is there and it's fairly common to see.
And certainly after having survived and continuing to survive in the COVID world, I mean, we certainly saw many physician offices closing or greatly reduced hours, particularly in the spring of 2020. Having seen that develop, does that raise any issues that you think should be placed into an employment contract to protect a physician who may not be able to meet WRVU requirements because of something like a pandemic that's outside of the physician's control?
Well, I always recommend to my clients that wherever there's some element of where they don't have control over patient workload, that they request some language in the agreement that basically says that they're not going to be penalized for not meeting these quotas or these patient levels or productivity levels if it's caused by some circumstance that's outside of their control. Especially when you're a new physician starting out in a new area, building up your practice, and you're dependent on the hospital to funnel you patients, it's important to have that kind of language in your agreement.
And I think almost all employment agreements contain a termination clause. And there's different types of termination clauses. Can you offer some insight on that issue?
Sure. Well, particularly with physicians, again, your first position outside of your fellowship or your residency, a lot of hospitals offer 2 or 3 year contracts. But these agreements also include mutual termination language for no cause. So what I like to tell my clients is that although you think you have a 3-year agreement, if there's a 90-day notice period where the other party can terminate your agreement for any reason or no reason, you really just have a 90-day agreement. So I think that's something important to keep in mind.
And certainly for cause, that would involve if a physician lost license to practice medicine, stealing, drug use, things of that nature.
Correct. Yes, if they lost privileges of the hospital, those sorts of things. There's a lot. I've noticed. I've reviewed agreements throughout the state of Pennsylvania for various hospital groups and practices, and I've seen a lot of consistency in the termination language. So a lot of it I have found to be reasonable language. It's just a matter of paying attention to the attendant circumstances to make sure that if one of those for cause termination clauses are triggered, that you're in the best position to move forward and protect yourself.
And certainly you mentioned earlier in our conversation non-competes. And non-competes, I think, are fairly common in physician contracts with health networks and really bar a physician from working for a period of time within a geographic location within his or her specialty. So have you seen sort of boilerplate or averages that you see in non-competes that limit a physician's ability to practice medicine outside of the network?
Yes. And to be enforceable, a non-compete must be reasonable in geographic scope, and it also needs to be reasonable in duration. So that's important to remember when you're reviewing these contracts. As far as geographic location, again, a lot of nuances in this area. You want to make sure when you're looking at the language of that provision, it can include 20 miles from your location, from your primary work location. It can be 20 miles from any location where you've provided services for that employer within the term of your employment, or it can be 20. I guess those are the two big ones.
Yeah, and I think the geographic range does, on some part, rest with where you're practicing. In other words, in urban areas, you may see smaller mileages, of 8 or 10 miles, but in the more rural areas of Pennsylvania, you may see a larger geographic limit to practicing. Have you found that as well?
Yes, absolutely. And it also it depends a lot on their what local competition they have. And, hospital systems are now spreading out over a very wide geographic area. So if they see a competitor encroaching closer and closer to their territory, you may find that non-compete going further and further out.
Okay. And then a non-compete will contain a duration of how long the physician can't practice medicine in his or her specialty within the geographic area. What kinds of limitations do you frequently see in these employment contracts?
I'm usually seeing between 1 and 2 years, usually no more than 2 years. These non-competes also come along with no solicitation. So that includes no solicitation of coworkers. So you have certain assistant staff that you like. You can't scoop them up and move them to your new employer within that same time period, or typically within that same time period. That would also apply to patients and sometimes to referral sources as well.
And I think some employment contracts are actually recognizing that a physician may want to leave the network, and they're putting right in the contract buyout provisions. And it's a dollar amount that one would pay the health network in order to leave and be able to practice in one specialty immediately. Yes. Have you begun to see those provisions as well?
I have seen those more frequently in recent years. And I like to equate them to, in a way, prenuptial agreements, that in the event no one likes to plan for termination at the end, but to some extent, it's nice to know what the damage is going to be before you terminate. Employers like it because it's sort of a hammer being held over the employee to keep them in that position. And employees, they're not always bad for employees either. They sort of know what they're up against if they're considering moving to another practice or opening their own practice within the range of the geographical limit that's set forth in the non-compete.
And certainly a physician who is thinking of leaving current employment, who has a non-compete, should talk to their new employer and advise them of the non-compete, but the employer may pay that buyout provision.
Yes, absolutely. The buyouts do tend to be, they're well over six figures. Often they're, what I've seen is close to what the position base salary would be for a year or two under the terms of the agreement. So they're not nominal amounts. They are fairly significant. And we always advise having that conversation up front with the employer, because if you start working for them and you don't disclose that you have a non-compete, and your former employer finds out about that, it can cause a lot of problems for you and your new employer.
And I think that probably wraps up with, given the time we have this morning, on the highlights. I think both you and I are willing to work with physicians on the negotiations can occur. Physician to employer, you don't necessarily need a lawyer. Reaching out to general counsel. Have you found that as well?
Yes, absolutely. I'd say almost all of my clients prefer to handle the active negotiation themselves, where I'll be behind the scenes. I'll help draft emails for them. I'll review emails that they've drafted, give them guidance on what to push back on, what not to push back on. We can be as involved or uninvolved as our clients would like us to be.
Okay, well, thank you very much, Karley. And I think our
Thank you.
contact information will be posted at the end of this video. So thank you.
Thank you.